Hello everyone, I am Geethanjali, a lawyer and a junior IP associate at Banana IP, an IP law firm in Bangalore. In this session of the Pan India Legal Literacy and Legal Awareness Program conducted by CEERA-NLSIU under the aegis of Department of Justice, Ministry of Law and Justice, Government of India, I am about to talk about mediation of matrimonial disputes. Now, regardless of where or which part of the world the wedding of a couple takes place, when they prefer to divorce each other, it is inevitable that they both have to reach the court of law and take the assistance of the justice system. Divorce can simply be explained as a decision to leave the partnership and end the marriage between the couple. Now, when it comes to court proceedings, especially related to family disputes and particularly divorce matters, there are three levels of courts that are involved. It includes family courts, the high courts, and the Supreme Court. Ideally, if we assume that the time spent in each of these courts to get the court order would range between 3 to 5 years, then by the end of the proceedings, the litigants would have spent anywhere close to 9 to 15 years in the court. Add to this the fact that in majority of court cases, the proceedings of the court become part of public records. This means that anyone can approach the court, pay a certain fee, and obtain details as to what transpired in the court of law in a particular case. What this further means to us in our discussion today is that in a majority of divorce cases, the details of the case and the court proceedings related to the parties involved, including details about their private life, will become part of public record and will also become accessible to the public at large. Then again, one cannot be completely sure of resolving their matrimonial disputes even after so many years of litigation, as there is always scope for dissatisfaction to either of the parties to a case in the end. In addition to this, say suppose one party approaches the court of law for divorce and the other party does not want to agree to be divorced, then one divorce petition could multiply into several cases, such as a petition for restitution of conjugal rights in case of violence or abuse, then a case under the Domestic Violence Act. In case there is a child or children involved, then a case related to custody and maintenance, so on and so forth. Another thing one has to understand is that the present legal system, more often than not, seems relatively rigid to deal with the sensitive issue like matrimonial disputes. This is because, unlike disputes arising out of contractual obligations, matrimonial disputes involve several dimensions, including emotions, social status, and personal commitments. The requirement of evidentiary support in the court of law to prove behavioral patterns such as cruelty, violence, etc., becomes extremely difficult to fulfill in a divorce proceedings. That said, formal litigation process to resolve matrimonial disputes could also turn out to be emotionally exhausting, especially when it involves child custody, support, and such other issues. Now, all of this could seem overwhelming to any couple who, as it is, would have been going through a rough patch to begin with. Additionally, this also puts a pressure on the justice delivery system, which are also overburdened with the number of cases and time intensive delivery of justice. There is an English idiom that reads to wash dirty linen in public. It basically refers to discussing or allowing to discuss in public the matters that should be kept private. Normally, people want to keep their private lives away from the critical eyes of the public. Hence, an improvised version of the idiom seems apt. No one wants to wash their dirty linen in public. Similarly, when it comes to matrimonial disputes, it involves not just the couple and their feelings, but their respective families, children, their economic situation, so on and so forth. And resolving conflict in such complex setup can get challenging and become a drag at the court of law. This is where alternative dispute resolution steps in to help mutually resolve their disputes in an effective, private, and time bound manner. Now, what is ADR or alternative dispute resolution? As the name suggests, is a type of dispute resolution that is alternative to traditional and general dispute resolution method, which is court litigation. ADR primarily relies on the intervention of a neutral third party to resolve the disputes and differences between the disputing parties. The classification of ADR is based on the level or the intensity of intervention of this neutral third party. It is majorly classified as negotiation, where only parties in dispute sit across the table, try to resolve their disputes. Here, there is rarely an intervention of a neutral third party. Mediation, where a neutral third party facilitates communication between the parties to a dispute. However, the mediator does not decide on the dispute but only facilitates communication. So the parties themselves can come up with settlement option. Conciliation, where the conciliator does everything that a mediator does, and additionally, they have the power to make suggestions related to settlement options to the parties. Arbitration, where neutral third party has the power to give legally enforceable awards. Other ADR systems include Lok Adalat, expert arbitration, online dispute resolution, etc. Although matrimonial disputes can be resolved through a combination of different ADR mechanisms such as conciliation and mediation, etc., for this session I will focus primarily on mediation. Now, mediation is a formally and legally recognized method of dispute resolution in India. It is an effective alternative to formal litigation to resolve matrimonial disputes, as this form of conflict resolution encourages communication between parties involved while maintaining confidentiality. It is less formal process of dispute resolution involving minimal legal technicalities and legal protocols. Mediation is a process where a safe space is provided for all parties involved in a dispute to express their opinions. Clear communication is facilitated between parties by the help of a third party who is generally called as the mediator. It is paramount that a mediator is a neutral third party who is capable of hearing both sides and providing or facilitating free flow of opinions to the other side, thereby helping resolve conflicts or disputes. Earlier, mediations happened through the intervention of elder family members, friends, relatives, etc. However, if observed closely, oftentimes there seems to be a bias towards one party in such family assisted mediation process. If that is the case, then it would lead to further complications of the dispute rather than providing a solution. This is where court assisted mediation comes into picture. More often than not, mediation offers a glimmer of hope for many couples to resolve their disputes either through separation or conjugation. Mediation, a part of ADR, is a mechanism in which a third party, known as the mediator, helps to solve family disputes by encouraging the participants to reach a voluntary agreement. Today, mediation is being used in the corporate world as well to settle disputes. The third party in the mediation process, like I was referring to earlier, is called as the mediator. Mediators do not give a judgment but allow resolution of the disagreements or disputes between the parties. Under mediation, open communication is held between the parties so that they can clear their doubts, misunderstanding, and with the help and suggestions of the mediator comes to a common conclusion. Mediation and the law. The right to have a speedy trial forms part of right to life as part of the fundamental rights enshrined in Article 21. For those of you who are familiar with the laws and with the existence of Arbitration and Conciliation Act, one would observe that unlike the Arbitration and Conciliation Act, there is no particular legislature to initiate the mediation process between the couple. The process can be initiated only by two ways: private mediation, where the parties voluntarily agree for mediation process; court assisted or court annexed mediation, where the courts refer mediation in accordance with Section 89 and Order 32A of the Civil Procedure Code 1908. When a couple approaches the court of law to file for divorce, then the judge refers some of those cases to mediation if they feel that there is a possibility of cohabitation between the couple. Additionally, mediation finds its legal presence under the Family Courts Act 1984. The Act provides the legal basis for the establishment of what is called as the family courts. Family courts, as the name suggests, help in resolving family disputes and in turn matrimonial disputes. They set up facilitation centers for conciliation and mediation to resolve family disputes in quick and effective manner. The Act provides for appointment of counselors to assist the couple in their dispute resolution process. The idea is to have the counselors deal with the matter to begin with, and if it fails, then to have the counselors refer the matter to mediation, where trained mediators can facilitate communication between parties to resolve matrimonial disputes. The procedural aspects of resolving family conflicts by mediation are outlined in Section 5 of the Act. This allows the government to order the Association of Social Welfare Organizations to assist family courts in divorce proceedings. Permanent counselors are appointed under Section 6 of the Act to effect and promote family settlements. Section 6 of the Family Courts Act makes it mandatory to settle a matrimonial dispute in relation to maintenance, child custody, divorce, etc. through the process of mediation. Mediation process. Divorce can be initiated by either of the spouses. However, mediation process requires consensus of both parties. Either of the parties may or may not opt to have a lawyer by their side to guide them through the mediation process. However, the presence of a mediator is essential to facilitate smooth and easy communication between the parties. Maximum period of mediation can be for 2 months or 60 days, though the same can be extended in case settlement is likely to happen. After the mediation process, if there is positive agreement between the couple, then they may give another chance to their relationship. In case mediation process fails, divorce shall not be granted immediately, but the court shall move on with the case in accordance with the procedure. Now, the functional stages involved in mediation are four in number: introduction and opening statement, joint session, separate sessions, and closing. I will deal with all four stages in detail. In the introduction and opening statement stage, the mediator will introduce themselves by giving information such as name, areas of specializations if any, and number of years of professional experience. Followed by this, the mediator informs the parties as to how they got appointed as a mediator to that particular case and if they have successfully mediated a similar case in the past. The mediator then expresses hope that the dispute is resolved peacefully and requests the counsels or the lawyers and the parties to introduce themselves. Each party is also given an opportunity to make their statements in this stage. The second stage is when the parties are allowed to present the detailed viewpoints and narrate their case, explain perspectives, vent emotions, express feelings without interruptions or challenges. Questions may be asked by the mediator to clear certain doubts at this stage for a better understanding between both the parties. The mediator in this session identifies the areas of agreement and disagreement. The parties may respond to points conveyed by the other party and, with the permission of the mediators, may even ask brief questions to them. Now, separate sessions in the third stage provide the mediator with more specific information and to follow up on the issues that were raised by the parties during the joint session. The mediator here takes into consideration emotional factors while dealing with sensitive issues at hand at a deeper level. It helps parties to realistically understand the case. The final stage, closing, is where the parties, having agreed upon the terms of settlement, reassemble the case with their advocates and the mediator confirms the terms of the statement orally. The terms are then reduced to writing and the parties sign the agreement. A copy of the signed agreement is furnished to the parties and the original signed agreement is sent to the referral court to pass an appropriate order. The mediator thanks the parties for their participation and congratulates them on taking a step towards mutual resolution of conflict. It is paramount that during all these stages, the mediator should ensure that they are impartial and create an environment where the parties are comfortable to open up. The mediator should ask effective questions and understand the issues. The mediator should also be accurate, brief, acknowledge the problems and emotions of the parties. Advantages of mediation to resolution of marital disputes. Confidentiality. Dispute resolution is a private matter, and this is the basic principle of mediation process. Neutrality. The trust of parties in the neutral third party is relatively higher due to the personal touch that mediation process allows. Party autonomy. Parties have control over the mediation process, and if at any point in time they feel like they need a break or have lost control, then they are free to walk away from the process. Win win situation. This dispute resolution is a means to an end. It gives a personalized solution to a dispute. One of the most essential and primary benefits of mediation as a mechanism for dispute resolution is that it can save a lot of time, cost, and also ensure confidentiality. In the case of Motiram versus Ashok Kumar, the court held that mediation proceedings are confidential proceedings. When mediator is required to send the report of successful proceeding to the court, they are not required to send what transpired during the proceedings. In case the mediation was unsuccessful, they only need to send the report stating mediation has been unsuccessful. In 2013, the Supreme Court of India, in the case of K. Srinivas Rao versus D.A. Deepa, stated that even in criminal and non compoundable cases where parties want to settle should be sent to mediation, making it necessary for divorce cases to be mediated if there is a scope of settlement between the parties. The Supreme Court also ordered to have pre litigation desks and clinics in all mediation centers of the country and to publicize the same to the masses so as to facilitate seamless resolution of matrimonial disputes without reaching the stage of litigation. Before we wind up for this session, I'd like to cover three aspects that are ancillary and relating to the resolution of matrimonial disputes. First of it being the NCPCR, that is, National Commission for Protection of Child Rights. Hague Convention on Civil Aspects of International Child Abduction deals with custodial issues of children of parents who are involved in troubled marriages and are located in different countries. The Ministry of Women and Child Development had been receiving a large number of complaints from such parents. In almost all cases, one of the parents have moved out with the child or children to India from the place of residence of the other parent located in another country. While these situations are dealt under the Hague Convention by the countries who are signatories, it is not possible for the parents of Indian origin to invoke the Hague Convention procedures as India has not signed the convention. The Ministry of Women and Child Development had observed that most of these complaints are from women who have had to escape from foreign countries along with their children to come to the safety of their own families residing in India. Their husbands file criminal cases of abduction of the children in the country where they are residing, which goes uncontested as the women in India are unable to present their case. In order to resolve the issue, the ministry had appointed a committee under Justice Rajesh Bindal. The committee has since submitted its recommendations, which are under examination. In the meantime, the ministry decided to set up an institutional mechanism to provide relief to the parents involved in such cases, keeping in view the best interest of the child. Exercising its power under Section 13A of the Commission for Protection of Child Rights Act 2005, the government has directed the NCPCR to constitute a mediation cell to resolve the cases of children who were taken away by one of the spouse without the permission of the other spouse due to marital discord or domestic violence from overseas country to India or vice versa, and prepare parental plan taking into account the best interest of the child. NCPCR came into existence in July 2018. The second aspect is the establishment of mediation centers at every district of the country, with an example of the Bangalore Mediation Center. Now, mediation centers are established in most of the districts of the country as part of the initiative of the respective high courts and to give effect to Section 89 of CPC. These mediation centers are supported by the respective advocates association by providing trained advocate cum mediators. In Bangalore, Karnataka, the same is set up as Bangalore Mediation Center or Nyaya Degula, and it provides a list of trained and experienced mediators to help assist in resolution of not just matrimonial disputes but several other civil disputes as well. It has a high success rate of settlement of disputes as well. Lastly, following the Supreme Court of India's 2018 order in the case of Nipun Saxena versus Union of India, all states of the country were directed to set up one stop center in every district. It is a victim centered survivor support system established in every district to support survivors of violence against women and girls. Government of India has also set up toll-free 24-hour helpline to women affected by violence seeking support and information. The details of both One Stop Center and Women Helplines are available on the Sakhi dashboard as shown in the slide. Now, time bound resolution of disputes depends majorly on the maturity and understanding of the couple involved and their desire to avoid regular court hearings and prefer private resolution of disputes. There is a mutual consensus between the parties towards reaching a solution that is acceptable to both, where they can exercise some control over the resolution. Mediation is generally less stressful than litigation, especially when children are present and inevitably become part of the divorce proceedings. Mediation allows children to see their parents cooperating even when they disagree with each other. By this, we come to the end of my presentation. I would like to express my gratitude towards CEERA-NLSIU for giving me the opportunity to conduct this session on resolution of matrimonial disputes through mediation. Thank you.